So we're just letting people in. We've got good numbers coming through just now. So for those of you who don't know me, my name is Martin Stone. I'm partner in the commercial services team here at Brody's, and I'll be presenting today alongside Grant Campbell, who you'll know from previous sessions, and my colleague Christine O'Neill, KC, who is our new speaker this time around, who will be joining us to talk about some case law update and regulatory guidance at the end of today's session. So if we just move on to the agenda, what we're going to cover today, I'm going to kick off with an update on the Data Use and Access Bill. I'm then going to hand over to Grant, who's going to talk about AI law and regulation and what's happened with that over the last 6 months or so. I'm then going to talk about some recent developments in relation to cyber resilience, including proposed new legislation and government guidance. And Grant's then going to talk about international transfers and some global developments and what we're seeing on that. And then Christine's going to pick up on a number of cases over the last few months and what they might mean for your organisation and some new guidance from the Information Commissioner. So as ever, we have a lot to cover. It always seems to be the day before this session, something drops out of the blue. And one of the things was proposed European Commission reforms to GDPR, amongst other regulations. We're not going to speak about that today, but I think just a good reminder about how many changes there are with this and how things are always changing. These particular proposals that came out yesterday are around simplifying regulations for SMEs, and so it'll be interesting to see how they evolve, particularly given that in the DUA bill, the UK government's previous government's proposed changes on that weren't taken forward, so we may actually see some deviation between the UK and the EU, but actually because of changes in EU GDPR, not through UK reforms. So let's go into the first section. So I'm going to talk a bit about the Data Use and Access Bill and where we are on that. So we've got the timeline on screen there. You'll remember from our last session back in November that the bill was introduced in October. It's been working its way through Parliament, so it went to the Commons in February of this year and completed that part of its journey in May time, and went back to the Lords, and we're now in a process of parliamentary ping pong just on some outstanding issues. So it's actually back in the Commons again today. It's been going backwards and forwards over the last week or so. What's interesting is actually the outstanding bits. The areas where there are disagreements between the Lords and the Commons are not actually to do with data protection law and the changes there, but to do with the sections dealing with digital verification services, which I'm going to go on to talk about, and an attempt by the Lords to introduce some provisions dealing with copyrighted works used in AI. So something that's not really core to the purpose of the bill, but the Lords have been trying to use the bill as a vehicle to introduce some changes. So back in the Commons again today, and we will see where it goes to those final couple of issues, but we would expect the bill to be passed in the coming months, and certainly before the summer. So one of the interesting things that has happened over the last couple of months, and you remember we did an update on, or an overview of the bill back on the previous session, is that for those of you that work for charities, the soft opt-in will now be available to you. So this was something that was in the previous government's bill, which didn't make it through before the general election last year, but wasn't included in the DUA bill when it was published in October. But following quite a lot of lobbying by the DMA and a number of large charities, the government in January introduced an amendment in the Lords to bring in the soft opt-in for charities. So that's good news for the third sector. As up until now, they've not been able to benefit from the soft opt-in in relation to marketing for fundraising and other purposes, because that's been outside the scope of the soft opt-in, but they will now be able to do that. And you'll see on the side there, the rules that apply to that. So it's got to be for direct marketing solely for the purposes of furthering a charitable objective. And then similar rules to the soft opt-in for goods and services, where you've got to give people the ability to opt out, and it's got to be for marketing similar things to that. So that's good for charities. We need to work through what it means around direct marketing solely for the purposes of furthering a charitable objective and how that might work with other marketing activities. But I think a good outcome for the sector, given it wasn't originally in the bill. The next thing I want to talk about on the bill is just around some of the other bits which have perhaps got less attention. And I think it's good time just now just to briefly talk about what those sections do. So one of the other main areas of the bill is around digital verification services. And what the bill is going to do on this is create a new framework for digital verification services in the UK. And this is all about enabling people to be able to prove their identity, their age, citizenship without needing hard copy ID, and ensuring that can be done digitally using a trusted framework. So under this section, the government will be able to publish a trust framework, which will set out the rules for digital verification services in the UK. And then DVS providers will be able to be certified against that framework. And if they meet the requirements to be certified, then they'll be included on a register of certified providers and also be able to use a trust mark so that individuals will know that that provider has been approved and is a trusted provider of DVS services. Now, you may say, why does this matter? Why are we covering it in this session? Well, a couple of reasons. So if you work for a public authority, then this part of the bill is going to create new information gateways between registered DVS providers and public authorities in relation to sharing of data held by public authorities and the DVS providers. So that's quite an important thing that public authorities will need to get their heads around in terms of how those information gateways are going to operate and what data is going to be shared. The second thing that might be of interest is around the ability of the Secretary of State to make regulations permitting the use of registered DVS providers to provide right to work or right to rent checks. So at the moment, you'll be aware that employers and landlords have certain obligations around doing certain checks on their employees or their tenants. There are some digital services out there that people can use, but what this part of the bill will do is actually ensure that that is now on a statutory footing, and the regulations will permit the use of those services. And I think then what's really interesting with this, from a data protection perspective, is actually that using DVS services for the purposes of verifying identity may actually be good for data minimization because you're not needing to collect the same level of data that you might otherwise do. So at the moment, if you need to verify someone's identity, you'll be perhaps collecting a copy of their passport or their driving license or other documents containing personal data, and you're then holding that. But if DVS is enabled and you can use DVS for verification, then that then means that you just simply need to do a check with a trusted provider, and you're not then collecting, holding, and having to think about what you're doing with that data. So quite interesting to see where the framework goes and what it enables in terms of how organisations are able to then verify identity digitally rather than collecting or using hard copy ID. And then the other section I want to talk about on the DUA bill is just around smart data. So this is another area which is carried forward from the previous bill. And this is about creating a framework under which the government can create what are called smart data schemes. And that's essentially a way of enabling consumers and businesses. This is not just about individuals, but about businesses as well, to allow third parties to access their data. And it very much takes the concept, the principles of open banking, which those of you in financial services will be very familiar with, and putting that on a broader statutory footing and enabling similar schemes in other sectors. So one example, and you see on the slide there, the government has talked about quite a lot is in relation to the energy sector. For example, making it easier for customers and consumers to share their energy consumption data to then get more accurate price comparisons. And things like carbon reporting for companies as well. So you'll see from what's covered by customer data and business data that these are quite broad categories. Lots of different data can be shared under these schemes. And these obligations will apply to traders that supply goods or services or digital content. And that will apply also whether or not those goods, services, or digital content are paid for or provided for free. And then the schemes that are set up, the regulations for these will set out rules that apply to the trader and also to the entity, the third party to whom that data is being shared. So quite interesting again in terms of taking the concept of open banking and widening that out to other sectors. And the government has identified that should lead to improvements to consumers, to businesses in terms of how they consume goods and services, and investment in that as well. So that was all I wanted to say on the DUA bill. As I say, we are at the moment in ping pong. It should be finished in hopefully in the next couple of months, if not sooner. So I would expect the bill to be finalised before the summer, and we'll then await and see what the timetable is for implementation of the changes and when they'll come into force. Grant, over to you to talk about adequacy.
Thank you. Morning, everyone. So those who attend regularly will know that international transfers is a regular item. I think this session, there's quite a lot going on. I mean, Martin mentioned the data protection fast-moving area, but there's been quite a lot of developments in the space of adequacy decisions. So I wanted to run through a number of those. We'll start with the EU's review of UK adequacy. It doesn't seem like yesterday that we were talking about whether or not the EU would recognise the UK initially after Brexit. Well, 4 years have gone and we're back round again to whether the EU will continue to recognise the UK as adequately protecting data. The original deadline was the 27th of June, but that has been extended by 6 months to the end of December this year. And the reason for that is the DUA bill. So the European Commission has said that the extension will allow time for the UK to conclude its legislative process. And then once that has been concluded, the Commission will assess whether the UK continues to provide an adequate level of protection and whether it will renew that decision. And the EDBB has said, European Data Protection Board, that this is an exceptional measure and they don't want it to go on any longer than 6 months. So actually the parliamentary timetable that Martin was talking about is actually quite important from an EU scrutiny perspective in terms of whether or not to allow the process to happen so that the adequacy decision can be reviewed and hopefully renewed before the end of the year. In terms of the review itself, the substantive review, well, the DUA bill, is a measure that is intended to simplify compliance and promote innovation. And under that bill, the UK's adequacy test may change to a standard, which is, does the third country protect data to a standard that is not materially lower than in the UK? And the EU's concern is that lowering of standards may affect onward transfers of data to third countries. So at the moment, we don't see any significant legal divergence, but EU bodies remain cautious. I think my view is it will be a surprise if the EU were not to renew the UK's adequacy decision. I think, as we can see, there has been a reset in relations between the EU and UK at a political level. And I think that will make the Commission keen to renew the adequacy decision. I suspect, though, there will be grumbles from maybe the EDBB and the European Parliament, but we will report on that towards the end of the year when we do our November session. In the meantime, just at the EU level, much as you were, so the EU has renewed existing adequacy decisions for 11 countries. No adequacy decisions have been revoked. The Japanese discussions are interesting in the sense that the adequacy decision is going to be renewed, but it may be deepened to include academia and public sector bodies. And I suppose what I think this brings us to is that the EU is looking to develop an international adequacy network. And I think there's 3 prongs to that. The first is renewing and modernising its existing adequacy decisions. I think, secondly, it's embedding data flows and privacy standards in trading agreements, and I'll come on to that when we look at the UK. And then I think, thirdly, and this is kind of soft power, we've talked in the past about data sovereignty, it's about trying to encourage other countries to enhance their privacy standards, but based around a model that is based on EU GDPR. So I think that's where the EU is going in terms of its adequacy decisions and its policy going forward. The UK adequacy regime is pretty similar. It hasn't changed so much in terms of the countries that have actually been recognised. So all the EU member states, Gibraltar, the 11 countries that have just had their adequacy decisions renewed, Japan, South Korea, and then, of course, there's the USA and the data privacy framework, which I will turn to shortly. And that proposed new DUA bill test may help the UK to strike adequacy deals with a wider range of countries. And the UK has, for some time, under the governments of various political persuasions, been signalling its interest in making its own future adequacy decisions for other countries. Next slide, please. And so I think this actually brings us to, from the UK signalling its intent to do things, and we're beginning to see how that is manifesting itself in a world that's has been changing quite radically since the Trump administration came back in the start of the year. So the UK announced a free trade agreement with India earlier this month, and whilst that it is not an adequacy decision. It is clearly the UK has made it clear that it isn't an adequacy decision. What it does, and we haven't got the full text because the negotiations are concluded, but the text is still being poured over. But what the UK has indicated is that the deal will facilitate data flows with India. And whilst there is no specific UK adequacy decision, both parties are committed to deepening and broadening their relationships. And India has recently passed in 2023 its own data protection legislation, and we can see that may pave the way for a future UK adequacy decision. I think one of the things that we've seen over the years has been that actually whether countries can actually get to the stage where they can make an adequacy finding tends to come from whether there is sufficient political will between the governments of both sides to actually get there in terms of setting up the mechanisms. And I think the Indian Free Trade Agreement may signal an intent on the part of both governments to get to a point where actually that adequacy decision could be made. So that is definitely one where we'll have to watch this space when we see how the Free Trade Agreement shapes up. The final thing that I wanted to cover was really the data privacy framework. So this was something that came out of the Schrems decisions. So very much a negotiation between the Biden administration and the EU to try and plug the gap that was left by the last Schrems decision. The privacy framework was reviewed in late 2024, and it was found broadly to be effective. A number of points were picked up, though, in that review. Particularly, I think that actually there didn't appear to be many complaints, and there didn't appear to be much happening on the US side under the framework. And I think that made the Europeans slightly nervous. So they provided various recommendations as to what they wanted to see happen. However, with the change in administration on the US side, I think there have been a number of things that have caused increased heightened concern on the EU side as to how the privacy framework is working on the US side. First one was the Privacy and Civil Liberties Oversight Board, an independent body that was one of the things that the EU was relying on to ensure that there was oversight of intelligence activities and effective redress, well, a number of the members of that board were removed by the Trump administration, basically the Democrats. And that body has been limping along for a number of months. And that has raised alarm within the EU as to whether or not the safeguards that are in the privacy framework have been weakened. And secondly, there's been an executive order from the Trump administration that has made bodies like the Federal Trade Commission, if they're going to take major regulatory action, those things are subject to White House review. And again, this, I think, is increasing concern on the EU side that the independent mechanisms that were put in the privacy framework are being weakened. So I think there are concerns that the data privacy framework's future reliability is being called into question. And while the Commission is still the Commission is monitoring this, it has not suspended something which is under review. So overall, where are we? I think the UK and EU are both refining their adequacy regimes amid a global changing environment. Trade agreements are increasingly being used to promote data flow compatibility. The EU's review of the UK adequacy will hinge on the final shape of the DUA bill, and we'll know more about that in the coming weeks. And I think tensions linger over the data privacy framework, and that is leading, I think, other people now to think, well, actually, should we be thinking about a fallback just in case that falls? So plenty happening. I will now hand back to Martin.
Thanks, Grant. So I'm going to talk for the next couple of minutes about cyber resilience and a number of new things that are coming out from the government in terms of proposed legislation and some guidance. So the first thing to mention, and I think we mentioned this on the previous session in November, in the King's speech last year, there was a proposal for a cybersecurity and resilience bill. And this really builds upon the NIS regulations from back in 2018, which are now 7 years old, based on an EU directive and well due an update. And on that note, the EU has introduced NIS 2, which came into force, had an enforced date of last autumn, and has made various changes to the NIS directive in the EU. So we got a little bit more detail on what the government's proposing on this in a ministerial update last month. And the key things I think to be aware of. So firstly, the sectors and entities that are going to be covered by the rules around cybersecurity, cyber resilience are going to be extended. We're not quite clear what that's going to be yet in terms of expansion, but certainly if you look at NIS 2, you can see there the move into new sectors and new entities being covered. So organisations currently outside the scope of the regulations may well find that they are within that with new duties around cybersecurity. And the big one, and I think the most interesting one, is around the extension of these rules to managed service providers. So many organisations will outsource their IT to a third party, and under the bill, many of those managed service providers will now come within scope. So that addresses one of the, I suppose, key risks for many organisations where you rely on a third party for your IT and your systems and networks. And that will put obligations on those third-party service providers in relation to the systems and platforms that they provide. So that, I think, will make a big change in terms of resilience of many organisations. The other important part of it, and following on from that, is around supply chain. So this is going to be a key focus of the bill. And there will be new supply chain duties on operators of essential services and relevant digital service providers. So we'll see new rules around what they need to be doing with their supply chain. And the government will also have the ability to designate certain entities as what they call critical suppliers. So they may take the view that a particular supplier is of incredible importance because various entities depend on that supplier, and the government can designate that entity, and then it will be subject to additional obligations. We'll also see new reporting obligations, for instance. The timescale for reporting, doing initial report, will uh, likely shift to 24 hours, with further detail to be provided after that. And there's also talk about new obligations in relation to reporting ransomware attacks as well. And you'll be aware there's been a bit of consultation with the government around whether or not there should be prohibitions on certain entities, for example, the public sector, on paying out ransoms as well. And that is likely to, the output of that will feed into the bill. And then the final point, as with many bits of legislation these days, there are broad powers for the Secretary of State to update the regulatory framework through secondary legislation so that it can be kept up to date. We will also possibly see data centres being brought within the scope of this as well. So they were designated as critical national infrastructure last year, and the government in the ministerial update is saying that they may bring them within the scope of this as well. So watch the space in terms of when the bill is published. We are told that will be in the course of 2025, and when we have that, we will provide some more detail. In the meantime, we had a couple of bits of guidance come out from the government. So the first of these is a new cyber governance code, and this was published earlier last month. And it's part of the government's modular approach to codes of practice for cybersecurity. And you can see on screen there how that fits in with the Cyber Essential scheme that we've had for a number of years, and various other codes of practice that have been developed or are about to be provided. And the purpose of the Cyber Governance Code is really to help boards and directors of organizations understand the key governance actions and things they should be doing to manage risk. So it sets out 5 key principles around risk management, strategy, people, incident planning, response, recovery, and assurance and oversight, and then sets out practical guidance against each of these points. So a list of actions under each of these headings of things that organizations should be doing. And that includes, for example, the frequency of internal reporting, how often you do testing and mock exercises, that kind of thing. And it's also accompanied by new guidance from the National Cybersecurity Centre. So the NCSC has provided cyber governance training that can be used by organisations, and a toolkit for boards as well. So these 3 bits together are free resources that are available from the government to help organisations to actually understand and manage cyber risk at a senior level, and use this as a checklist for their approach and their compliance. The other thing I want to talk about is the Software Security Code of Practice. So this was published earlier this month. And this is a voluntary code which is designed to help improve security and resilience of software, and is trying to address a number of concerns, for example, around what the government perceives as avoidable weaknesses in software development and maintenance, where there are vulnerabilities which could, with better practice, be avoided, and also to address poor communication between software suppliers and their customers around incidents and vulnerabilities. So this code is, I suppose, intended to do 2 things. One, it's provide support for software vendors, but it's also designed to help their customers to, if that can be referenced in contracts or tender processes, then customers can use that as assurance in relation to the steps that their software vendor is taking. 14 principles in the code around a number of different themes, and it takes a different approach depending on the nature of the vendor. So whether you're a developer, whether you're a reseller, whether you're developing open source software or maintaining it, there's different principles apply to different parts of that. So it'd be interesting to see how this is adopted. It was developed in consultation with industry, but whether or not large vendors adopt it remains to be seen, and whether customers require that as well. We'll see what happens with that, and whether there is a broad uptake of this. But certainly something to keep an eye on. And if you are in the process of procuring new software, it may be something that you want to use as part of your tender process to understand the steps that your vendors are taking around cybersecurity. That's all I was going to say on cyber. Back to Grant for an update on developments in AI.
Thank you, Martin. So, yes, developments in AI law and regulation. Uh, those of you who attend our commercial law webinars will know that we cover AI and the laws governing AI in much more detail than we do in our data protection update, primarily because we're looking at this through a data protection prism. So I'm not going to spend lots of time talking about the underlying legislation, particularly in the EU, but I think it is important to set a little bit of background just for a compare and contrast with the EU's approach and the UK's approach, and that leads into a discussion about how the UK is progressing. The EU AI Act was billed with a big fanfare as the world's first comprehensive law regulating AI. It is wider territorial scope than you would think, because it regulates anyone placing on the market or putting into service AI systems in the Union, irrespective of where these providers are established, whether they're in the EU or third country. And in many ways, it's not dissimilar. But we have GDPR. If you target in the EU, then they want to regulate. That activity to protect their citizens. And it's a risk-based approach, so based on everything from minimal risk, which is largely unregulated, going up through limited risk to high risk, and then finally up to unacceptable risk, which has been already prohibited. So, and there's a phased implementation over a course of 2-year period. So in February, we had the ban on systems posing unacceptable risk. We've got key dates in August this year and then February next year for the switch on of more and more of those provisions within the legislation. The UK have chosen a different path. So, and I'm going to start looking at this more from the data protection perspective. But the UK has shied away from passing AI laws at the moment. Its approach has been to reform existing laws. So the UK has been reforming its data protection rules to support AI, and I'll come on to what the ICO has been saying, and the plans for a new code of practice for AI and automated decisions. But the UK regulators, so there's been a sectoral approach with the UK regulators aiming to align with global norms while staying flexible. And again, that part is because the UK, I think, is keener to see AI embraced and sees it as a mechanism to activate economic growth. So the UK's preferred position has been to rely on guidance and codes on a sectoral basis and not to directly legislate. But I think that approach is changing. So the change of government last year, we have a Labour government now, and it responded to a committee report from the Science, Innovation and Technology Committee, which was saying that actually there may be the need for some direct legislation to regulate AI, and that a sectoral specific regulatory approach may not be sufficient. And the government responded to that report saying that it agreed, but that it felt that any legislation that it brought forward would need to be narrow and targeted. So very much in contrast to the EU's approach, which is to comprehensively regulate, comprehensively legislate, what they are saying is that it should be narrow and specific. And I think the sense is that it'll be in areas around safety and accountability for kind of advanced or frontier AI systems, rather than trying to generally legislate for absolutely everything. So this marks a shift from the government's previous approach, where it was planned. The idea under the previous Conservative government was to leave it to the regulators to develop their own specific AI guidance. So feeling that may not be sufficient, any legislation we don't yet know what that will look like. And I think from what I've seen, the government ministers have suggested that the timeline for any AI legislation is likely to be 18 months. So nothing specific to happen immediately, but be aware that AI specific legislation is on the government's agenda. And we'll have to see how that will tie in with the existing data protection law and indeed the GEO bill, although that will long be passed into law before anything comes out, but it will be moving. So what have we got in terms of views from regulators? I'm going to concentrate on the ICO. So the ICO last year consulted in a number of areas in terms of setting out what its views were and looking for industry and all interested stakeholders to come back with views. And this is all about the regulator trying to understand how a generative AI is being developed, how it is being used, in order that it can actually come up with regulation or indeed or guidance as that will actually work in the context of what is going on. The regulators are very keen to be seen to be plugged in to how AI is actually being used. So there were consultations on a number of things. Firstly, web scraping, and actually, what the ICO's view on that was, yes, there are legitimate interests in, and that could be a valid lawful basis for scraping data from the web. But if you're going to do that, you need to have a legitimate interest assessment, and you actually need to show that scraping is necessary and that there aren't other ways for you to obtain the particular data. It consulted on purposes and setting out how developers must set out clear purposes and explain what data they're processing, why, and in what stage, and if data is going to be reused. They need to have a look. They need to consider carefully whether or not the new purpose is compatible with the original one. A lot of focus on the accuracy of training data, saying that developers need to have a really good understanding of the accuracy of the training data they're using, and they need to communicate this to users. ICO was particularly focused on individual rights and making sure the developers have effective processes for individuals to exercise their rights and to integrate safeguards into the processing. There were some discussion around Article 11, which is about processing which does not require identification of data. And whilst the ICO said that yes, Article 11 may have some application, it was not something that everybody could just use simply to try and avoid having to do anything in terms of individual rights. So whilst Article 11 had a place, it was not a panacea for developers to be able to totally wriggle out of any data protection responsibilities. And then the final paper was around controllership and whether people involved in the AI supply chain were controllers or processors. And the ICO was very much hinting that in its view, the likelihood was that many of the relationships that were being created were actually joint controllerships. And the ICO was encouraging developers and deployers and others involved in the supply chain to embrace that rather than trying to avoid it. I think the themes that for me that came out of all of these exercises were, firstly, the ICO's view is that normal data protection rules apply to AI in the same way as they apply to everything else. Those involved in the AI industry can't just say it's too difficult to apply data protection rules to what they're doing. That won't wash. And then finally, you need to build, if you're involved in developing and deploying AI, you need to build compliance into what you're doing. So no shortcuts, I think, was the ICO's view on that. And then what this has led to, I think, is that the ICO announced in March that it intends to introduce a new statutory code of practice for private and public sector businesses on developing and deploying AI. And the aim is to set out a clear set of rules to strengthen the UK's position as a global leader in AI. And I think this is one of the things that I think's been different between the UK and the EU. The regulator here very much has one eye on what is actually going to stimulate innovation within the UK. It's not just simply a case of trying to lock things down and just look at it totally through a privacy lens. The regulator is trying to balance ensuring that privacy interests are respected whilst also not inhibiting economic growth. So simpler guidance will be introduced to introduce clarity on data protection law, helping businesses to harness these opportunities while safeguarding personal data. And we'll see, the ICO hopes that the framework will guide AI adoption and technological advancement and finally enhance public trust. And I suppose I'm just reflecting here on a couple of areas where I think there are some slight differences emerging between the UK and the EU. So, and in part, this comes out of the DUA bill, and part comes out of the EU's approach to legislating for AI. So, automated decision making as part of the DUA bill, the aim is to make it easier or to loosen some of the restrictions and some of the prohibitions under the current GDPR for making automated decisions. And clearly that is something that AI could do. So the aim here is to relax some of the rules, not where special category data is involved, but in terms of low risk scenarios, making it easier to make automated decisions, and where there are significant decisions, then subject to safeguards, removing the prohibition that would generally apply, and then only then special category data being subject to the same rules as apply currently under GDPR. In relation to impact assessments, the EU, the AI Act, introduces the Fundamental Rights Impact Assessment, which is focused very much on AI and the AI systems. We don't have that because we don't have the Act. So actually, but we still have the data privacy impact assessments, and the ICO has been very much stressing that it will expect that many DPIs will be required for AI use. And so it will be interesting to see as things develop, how much of a difference the lack of a fundamental rights impact assessment makes, or whether actually the ICO's expectations for DPIAs will in effect mean that many of the issues that would be covered under the fundamental rights impact assessment will be covered by the DPIA. And as I mentioned earlier, in the context of AI legislation, whether or not the UK's legislation when it comes will in any way help to bridge that gap. And then just finally on biometric data, the EU AI Act, introduced a ban on real-time biometric identification in public spaces and a ban on biometric categorization and emotion recognition in key settings. Now, UK again doesn't have that act, but actually in substance, the ICO's views and the guidance very much is trying to ensure that the use of biometric data is only in very responsible use, and has warned against bias and unscientific biometric claims in AI. So how much difference there is in substance and in practice remains to be seen. But these are just a couple of areas where I think there are potentially areas of divergence. And I suppose then just finally, on the global and multilateral initiatives, Council of Europe adopted a binding AI and rights treaty. It is very high level. It relies on those who are signatories to then adhere to the principles in it, but the UK and EU are both signatories to that convention. The G7 and OECD have issued various codes of conduct for advanced AI models. And we see in the US executive orders on AI mandates for federal risk reviews. And I think all of it addresses a number of key points, which are transparency, safety, and privacy in AI. So you can see that there are some themes that are emerging through all of these various initiatives. I'll hand over now to Christine, who's going to talk about case law and ICO guidance. Christine.
Hello, everybody. So if we move on to the next slide, what I'm going to do is just give you a very high level overview of some developments in the last few months in chronological order. And what's interesting, I think, is that we've had at least two court cases, and oftentimes, as you'll know, a lot of data protection disputes rest in the tribunal rather than making it into the court system itself. But there are two, I think, that are worth making mention of. The first from January of this year is Ashley against HMRC. That is Mike Ashley, who will be known to you for other reasons, and this arose out of a tax investigation into one of Mr. Ashley's tax returns. Following that, he made subject access requests of HMRC, and I think it's fair to say from the case report, it appears that HMRC perhaps didn't clothe themselves in glory in terms of process. But in the High Court, there is guidance on a number of issues that might be worth your attention. First, on the scope of the request that he had made, he made a request in very broad terms for all data relating to the revenues inquiry and relating to him for the relevant tax year. And one of the things that the court considered was whether the revenues process of treating its main revenue functions separately from those carried out by its valuation office agency was appropriate, because they had not returned to him data processed by the valuation office agency. And the court, perhaps unsurprisingly, said that that wasn't permissible and the revenue couldn't unilaterally alter its obligations by an internal practice of treating the main part of its functions and the valuation office agency separately. So that's a kind of warning against internal walls. There was also discussion of what is involved in the question of disproportionate effort. So when a subject access request can be refused or not complied with on the grounds that doing so would involve disproportionate effort. One of the interesting things said by the High Court was that when you're making that assessment, you're not only talking about the process of finding the relevant data, but also time spent addressing whether exemptions apply to that personal data. However, the burden is on the data controller to show that supplying the information would indeed involve disproportionate effort. But that's quite an interesting part of the judgment to read. There's also quite a complicated discussion about when personal data is personal data, or when data is personal data, and the court referring to the revenue taking too narrow an approach to when information would amount to personal data. And again, Durant is referred to and discussed in that part of the judgment too. And then also, if you're applying exemptions to withhold certain personal data in response to a data subject access request, the exemption relied on by the revenue here was, of course, that disclosing the data would prejudice the assessment or collection of tax. The point was, in terms of the court consideration, that that prejudice has to be likely, and to be likely, there has to be a very significant and weighty chance of that prejudice occurring, and that would require evidence. So a warning again about the level or standard to be met when you are applying exemptions. RTM against Bonterre is about betting and gaming platforms operated by Sky. Sky Betting and Gaming. Very interesting case about consent. Now, it's quite specific to the gambling environment, because there's quite a lot of discussion about the very particular circumstances that apply where you have vulnerable people involved in gambling. The claimant here was someone who they themselves claimed to be a compulsive gambler and who had been targeted, he said, by direct marketing as a result of the respondent having obtained data through cookies and the like in order to direct marketing material to him. Again, it's quite a lengthy and quite a detailed decision, but worth looking at around the question of the quality of consent that's needed in order to fulfill the consent requirements. The next four items are really connected with the ICO, so not litigation. The first is the ICO reprimanding Scottish local authorities. I shouldn't laugh, but the language is interesting. But the ICO has had something of a sustained practice of scrutinising Scottish local authorities over the last several years in relation to timescales for responding to data subject access requests. Interestingly, the ICO acknowledges that many of the problems are a consequence of resource and budget constraints, but nevertheless is prepared to take enforcement action if it doesn't see improvement. In March, and as many of you will be aware, the ICO issued its first fine against a data processor as opposed to a data controller against Advanced Computer Software Group. This was in consequence of a ransomware attack in 2022, which resulted in the loss of data relating to around 80,000 people, including details of how to gain entry into the home of nearly 900 people who were receiving care at home. The fines related to failings in relation to data security measures, including an absence of multi-factor authentication, inadequate vulnerability scanning, and inadequate patch management. So really just again a signal that being a data processor doesn't get you out of these regimes and the potential for a penalty. Also in March, excuse me, the ICO issued quite detailed guidance on anonymisation and pseudonymisation, which time does not permit us to discuss in any detail this morning, but worth a look if you are engaged in that kind of activity. And finally, April 2025, I've chosen this one. This is an announcement by the ICO last month about the British Library. And what the ICO has said in relation to that that matter is, as again you may know, the British Library had a ransomware attack in 2023. And what it did in response to that was to publish a very detailed cyber incident review the following year. And what the ICO says is that we commend the British Library for being open and transparent about its system vulnerabilities that contributed to the incident, the impact it has had, and the improvements made so far to protect people's personal information. Having carefully considered this case, the Information Commissioner decided that due to current priorities, further investigation would not be the most effective use of resources. And to me, that's a signal that if you confess, and if you confess publicly and fully, that may be of assistance to you in responding to ICO investigations or inquiries. And that is all I think there is time to talk about if we want to have a couple of questions from our participants.
Thank you, Christine. Yeah, we've had a couple of questions in. Let me just find them on screen. Not surprisingly, given, I suppose, recent events with M&S and Co-op, there are a couple around cyber security. Just following, Christine, what you were saying there around the British Library. An interesting one, someone's asked why, in relation to the software vendors code of practice, why the sector didn't, the IT sector didn't go for an ICO certification or code of conduct under UK GDPR. And I think the answer to that is, firstly, it's a very difficult thing to do, to get an industry together to actually come up with a code that everyone agrees on, and then get it through the approval process. So that's the first reason. But secondly, those codes of practice and certifications deal only with data protection issues. And of course, cyber, as we've seen with M&S and Co-op and the disruption that's caused, is a much wider issue. It's not just about personal data, but actually about interruption to businesses, to organizations generally, whether that is ensuring that lorries are turning up with the right stock for a shop in a remote area or running online orders. It's not really just about personal data, but very little about that. It's actually the wider disruption. So I suspect that's probably why we've not yet seen anything on that from the software industry. Grant, a couple of questions for you. So given what you said about the EU-US data privacy framework and the concerns that have been expressed on that, is there a concern that the effectiveness of other transfer mechanisms for international transfers might be or are likely to be affected?
Well, I think yes, there is a concern. I mean, we don't know yet what is going to happen with the privacy framework, whether or not the concerns that are being expressed at EU level are going to lead to action being taken. Clearly, there are wider conversations going on between the EU and the US in the context of trade and tariffs and all these kinds of things. And it may be that something like that will lead to an outcome on this that means that this mechanism doesn't go. But there are also news articles at the moment about FISA, so the Foreign Intelligence Surveillance Act, Section 702, which was something that was at the heart of the concerns that were expressed in Schrems, and that is up for renewal. So again, will there be things there that are going to change the wider landscape in the US for the protection of personal data? And if these things do happen, then certainly in an EU context, that makes it more difficult then to justify some of the use of these other transfer mechanisms. And it may be that there's slightly different outcomes in the UK because there's a slightly different approach to assessing risk in the context of transfer. So I think it's an interesting question, and it's one that we'll have to keep an eye out on the detail. But I think a lot of organisations have been using over the years a multi-layered approach to this on the basis that if one mechanism gets knocked down, you've got another one to rely on. So I think watch this space. We'll know a bit more, I think, in 6 months.
Thank you. Good question on digital verification services and how they'll be accessed, and would a company have to pay to subscribe to that service, or how would it be funded? So, yeah, I mean, the answer to that is it would be funded by the users of those services. And it's worth saying, there are already a number of providers who would provide you with right to work checks or right to rent checks, and they charge organizations a fee for doing that. What the government says is that they think that the cost saving for organizations in terms of efficiency and time of using these digital checks actually means that while organizations have to pay to use them, there's a net saving there for business in terms of the checks which they are required by law to carry out. So yes, it will be funded, but the view of the government in the paper when they announced the bill is that actually there will be, by enabling these services and providing greater trust in them, there will be a net saving to businesses generally. One more question, Grant, just on the ICO's code of practice for AI. Do we have any timescales on that? Do we know when it's likely to arrive?
No, I mean, if it's a statutory code of practice, it'll need to get approved through government. So no, I don't have a firm timeline in mind. But I think the ICO will be very, very keen, because it's going to be based on a lot of work that's already done. We'll be very keen to get that moving.
And one final question for you, just has there been any discussion around the UK having a dedicated AI regulator in the way that some other countries have done?
I think the working assumption, certainly my working assumption, there always been that this would involve an enhanced role for the ICO, as the ICO is not really sector specific. But I think there has been some suggestion from government ministers that they may look at creating a specific AI regulator. So it will be interesting. A number of other countries have gone for the AI specific regulator approach, and that may be something that's on the table in the UK.
Great. Thank you very much. Well, that's us at midday, so that's the end of our time for this. Just two quick requests from me. Firstly, we have our commercial law update on the 4th of September, so you can sign up for that now if you're interested in doing so. I think on that, that's the end of today's session. Thank you very much for joining, and we look forward to seeing you again soon. Thank you.
Thank you.